Welcome. It's great to have you here. And this is literally the first time that I'm going live using this new setup. So this is going to be a little bit experimental. So just bear with me on that. Also just getting used to how this software works. Shouldn't be an issue though. Drop some love in the chat. Let me know if you can hear me okay. Let me know if you can see me okay, if you can hear me okay. Any feedback at all, because I'd rather take care of that on the front end than run into an issue later on. Oh, this is exciting. I'm actually a little bit nervous. For those of you who don't know me, I'm David Greenberg, and I'm the founder and creator of conditionalacceptance.com. And actually, on that note, we're going to be, some of you guys already know, we're going to be relaunching the brand under a new brand. I'm not quite ready to announce that yet, but it's going to be coming up soon. But I'm obviously pre-framing that by letting you know that we're going to be launching under a new brand. So I appreciate you. Looks like we have a couple of people joining us on YouTube. Galt for Prez. I'm assuming that's a reference to Ayn Rand's book, Atlas Shrugged. We have Vivian in the house. Great to see you. And we have Hungry Boy 1. Appreciate you too. So what we're going to do for this live stream, this is going to be probably the first in a series. And so what I want to do specifically is I want to start to read a book or a pamphlet called Creditors and Their Bonds, which is going to be very important. And what I'll also do as I'm reading it is I'll pause occasionally, and if you guys have specific questions or feedback that you want to share, I want to make it interactive. I probably won't do it this time, but maybe for future streams, what I'll do is I actually allow people to come backstage and you can actually join me live on the stream. But we probably won't do that this time. But that's something I do want to do in the near future to start to make this a little more interactive. So I've been wanting to do this for a while because this book, Creditors and Their Bonds, is just packed with valuable information. And yeah, so this is going to be helpful for those of you who've decided to join us on this journey, for whom sovereignty is important, taking control of your affairs, starting to operate in the private, and generally not being afraid of the court system, but also understanding it, how it operates, the theater of the court. This book is going to be very powerful. And it's just, like I said, it's chock full of gems. We're going to go as slow as we need to. The book is, how many pages is it? 125 pages on the PDF that I have. I don't even know how many live sessions we're going to have to do to go through it, but there's really no rush, right? I'd rather you get the most maximum value out of it than to try to rush to finish it. Okay, so that's my perspective. You guys know, those of you guys who've already come to some of my live events or who maybe have attended the live study sessions, you know that that's my style. So let me see, any quick announcements here. So like I already mentioned about the branding. Right now, we're not doing any live workshops for the foreseeable future, but these live sessions will kind of fill in the gaps. So that's part of the reason why I wanted to do that. If you want to get more tightly involved, then check out the membership on the website and just, jump in there and see what resonates. There's a lot of great information on the website. And when we launch under the new brand, we'll just take everything and put it on the new website. It'll be seamless. So don't worry about that. Okay, drop some love in the chat. Looks like we have about 17 people watching, which is great. Keep it up. Actually 20 now. Awesome. Awesome. Love it. Vivian says aloha from Hawaii. Love your work. Thanks, Vivian. I appreciate you very much. I definitely appreciate you. And I appreciate all of you. So let's start reading. And like I said, I will pause from time to time to just check in with you guys. Creditors and Their Bonds, a quick guide to the administrative process in public courts. The law of cause and effect. So comment in the chat, how many of you are already students of natural law? How many of you are already students of natural law and have studied, for example, you may have read the Kybalion, which is a treatise based on the 7 Hermetic principles, or you may have just been initiated into the occult through some study, really any teaching at all. So just comment in the chat if you are familiar with and have already started your study of natural law. So let's keep reading here. The law of cause and effect. Every effect has a cause. Every cause starts with a thought. Remedy starts by changing your thinking. Every action generates a force of energy that returns to us in like kind. What we sow is what we reap. And when we choose actions that bring happiness and success to others, the fruit of our karma is happiness and success. And that's a quote from The 7 Spiritual Laws of Success by Deepak Chopra. The laws under which we live operate to our advantage. All conditions and experiences that come to us for our use for our benefit. We gain strength in proportion to the effort expended. Our happiness is best attained through a conscious cooperation with natural laws. The laws under which we live are designed solely for our advantage. These laws are immutable, and we cannot escape their operation. Difficulties, disharmonies, and obstacles indicate that we are either refusing to give up what we no longer need or refusing to accept what we require. All conditions and experiences that come to us do so for our benefit. Difficulties and obstacles will continue to come until we absorb their wisdom and gather from them the essentials of further growth. That we reap what we sow is mathematically exact. We gain permanent strength exactly to the extent of the efforts required to overcome difficulties. And that's quoted from the Delphin System, Transforming the Way the World Thinks. So let me see what you guys are saying over here. Is that resonating at all? Does that resonate at all with you? Let me know what you guys think. Is that resonating at all, what I just read? Because I can tell you from my experience, it does. From my experience, it does. Let's keep reading here. It's great to see you guys here. We have some new folks in the room. Awesome. You guys doing great. Help me to promote this. Drop a like on wherever you're watching this video. So if you're watching on YouTube, drop a like. If you're watching on Facebook, drop a like, a thumbs up. Help push this out, because that's what happens when you. That's essentially how you pay for this live stream, by putting a like on it. That's going to help me to reach more people. So let's keep going here. effort, deliberate exertion of physical or mental power, from the Random House Dictionary. Commit thy works unto the Lord, and thy thoughts shall be established. That's from Proverbs 16:3. The Lord of hosts hath sworn, saying, surely, as I have thought, so shall it come to pass. And as I have purposed, so shall it stand. That's from Isaiah 14:24. Where a man's ways please the Lord, he maketh even his enemies to be at peace with him. That's from Proverbs 16:7. Be not deceived. God is not mocked. For whatever a man soweth, that shall he also reap. That's from Galatians 6:7. An elder Cherokee Native American was teaching his grandchildren about life. He said to them, a fight is going on inside me. It is a terrible fight, and it is between two wolves. One wolf represents fear, anger, envy, sorrow, regret, greed, arrogance, self-pity, guilt, resentment, inferiority, lies, false pride, superiority, and ego. The other stands for joy, peace, love, hope, sharing, serenity, humility, kindness, benevolence, friendship, empathy, generosity, truth, compassion, and faith. The same fight is going on inside you and inside every other person too. They thought about it for a minute, and then one child asked his grandfather, which wolf will win? The old Cherokee simply replied, the one you feed. Let's see what you guys are, how you guys are doing. Appreciate that. Hungry Boy says, natural law is the most pleasant. It's the first time I've heard natural law be referred to as pleasant, but sure. Yeah, it's a great way to describe it. It's a great way to describe it. You guys are doing awesome. Let's keep going here. Why do I have an exemption? You have an exemption because you have no money. There is a constitutional prohibition against paper money. A country, in parentheses, a state, has to have a name, people, boundaries, and money. If one of these elements is missing, there is no country. If Connecticut has no people, it is not a state. If it has no geographic boundaries, it is not a state. If it has no money, it is not a state. Look at the cause and effect. Why is there no money in circulation? Who had authority to demand the money be given to the Federal Reserve banks by May 1st, 1933? The money is in trust for the people in the states. constructive trusts, in parentheses, necessary when fraud is involved, no unjust enrichment. Okay, and we're going to be talking a lot about trusts as we go through this. So how many of you guys are familiar with trusts? Comment below. How many of you guys are familiar with trust, and how many are you familiar with what happened in 1933? I know some of you, probably a lot of you guys are. I just kind of want to see where people are at. How many of you are familiar with what happened in 1933? And also, how many are you familiar with trusts and trust law? Brian says, not familiar with them, just starting to learn. That's amazing. You're ready to go. Ready to jump on. Your learning starts now. There's no time like the present. Michael James reminds us of the Emergency Banking Act. And Galt for president, Galt for Prez reminds us of House Joint Resolution 192. So go read that. Go read that in its entirety. It's actually not very long, but you're going to want to start to familiarize yourself with that. So let's keep going here. You cannot pay. He who has the gold pays the bills. You are exempt. He who demands payment knows, or should know, there is no money. You are not expected to pay. You loaned your substance, you loaned all your substance to the fiction by application and registration. You have nothing but possession. You have no titles to substance. You only have title to your rights. Everything is prepaid. Exemption. Freedom from a duty, liability, or other requirement. And that's from Black's Law Dictionary, 7th edition. Mistake, mistake, mistake equals cause. Some unintentional act, omission, or error arising from ignorance, surprise, imposition, or misplaced confidence. A mistake exists when a person, under some erroneous conviction of law or fact, does or omits to do some act which, but for the erroneous conviction, he would not have done or omitted. It may arise either from unconsciousness, ignorance, forgetfulness, imposition, or misplaced confidence. And that's from Black's Law, 4th edition. UCC, which is the Uniform Commercial Code 1-103, supplementary general principles of law applicable. Unless displaced by the particular provisions of this act, the principles of law and equity, including the law merchant and the law relative to capacity to contract, principal and agent, estoppel, fraud, misrepresentation, duress, coercion, mistake, bankruptcy, or other validating or invalidating cause, shall supplement its provisions. Okay? You guys getting this? Checking in with y'all. Wow, we're almost up to 40 people on the stream, so we've almost doubled it. Throw down some love on this stream. Smash the heck out of that like button wherever you're watching this. Okay. David says, good day from Alaska. Hey, good day. I'm actually closer to Alaska than I've been in a long time because I'm here in Washington State, but only until Sunday night, when I'll be flying down to Cali in Colombia in South America. But it's great to see you guys. Poppy Gold says law merchant. Yeah, law merchant is the law merchant is an ancient law. This is nothing new. In a way, we're kind of uncovering and discovering something that's been around for a very long time. Okay, the Uniform Commercial Code is just a modern or a more recent manifestation of ancient principles. Okay, so that's really important to keep in mind. This is not new stuff. Not new. And it's okay if it takes you a minute to catch up. I mean, I've been studying this stuff pretty intensely for almost 2 years, and I in some ways I feel like I'm just catching my stride. So if you're brand new to this, give yourself a break. But keep going. Keep studying. All right, let's keep going here. So again, for those of you who are just jumping in here, we are reading from Creditors and Their Bonds. And we're just taking it at pace, which means, we're probably going to have to do this over a couple of different live streams. So we're just going to take it at pace. We're not rushing here at all. And just as a reminder, if you guys do have questions, feel free to throw them down in the comments. I am monitoring here on the stream every once in a while. I'm jumping in here just to check on you guys. So if you do have specific questions that are relevant in context or anything that you want to share, go ahead and do that. Can I get into trouble using a bill of exchange? Can I get into trouble using a bill of exchange? Well, you can get into trouble crossing the street. There are rules for crossing the street and rules for using bills of exchange. Bill of exchange, an unconditional order in writing addressed by one person to another, signed by the person giving it, requiring the person to whom it is addressed to pay on demand or at a fixed or determinable future time a sum certain of money to order or to bearer. Sometimes called a trade acceptance, and in brackets also called a letter of exchange. So written order from A or B to pay C. And that's from Black's Law Dictionary, 4th edition. Bill of exchange. Comment in the chat if you are familiar with the concept of a bill of exchange and with negotiable instruments in general. Just comment what's your familiarity with negotiable instruments and bills of exchange. All right, we're going up. We got 42 people on the stream now. Smash to that like button. Great to see you guys. All right. Angela is recommending that we read Invisible Contracts by George Mercer. I appreciate that. It's a great suggestion. I have not read that myself, so I will take that under advisement. Thank you so much, Angela. So in our definition, we refer to trade acceptance. So let's look at that. Trade acceptance, a draft or bill of exchange drawn by the seller on the purchaser of goods sold and accepted by the purchaser. Seems pretty straightforward. A draft or bill of exchange drawn by the seller on the purchaser of goods sold and accepted by the purchaser. That's from Black's Law Dictionary, 4th edition. Let's look at negotiable instrument. Negotiable instrument from UCC 3-104. That's Article 3. I'm sorry, I think it's called Title 3 or Article 3, Chapter 104, Item E. Okay, an instrument is a note if it is a promise, and is a draft if it is an order. If an instrument falls within the definition of both note and draft, a person entitled to enforce the instrument may treat it as either. Okay, that's a very interesting little wrinkle there. And that's from Black's Law Dictionary, 4th edition. So negotiable instrument. Letter of credit. Letter of credit. Let's look at that. Credit instrument issued by a bank, John with capital J, guaranteeing payments on behalf of its customer, John in all capital letters, to a beneficiary, in parentheses, creditor. Normally to a third party, in parentheses, creditor, but sometimes to the bank's customer, John in all capital letters, for the stated period of time and when certain conditions are met. Letter substituting the bank's, John's credit, for the credit of another party, and that's from Barron's Dictionary. Barron's Dictionary of Banking Terms, Thomas Fitch, 2nd edition. So an instrument, what is an instrument? Let's look that up. What is an instrument? What is an instrument? In banking, an instrument refers to a contract or document that represents a financial asset or liability. These instruments facilitate financial transactions, transferring obligations or risks between organizations. They can take various forms. Okay, cash and cash equivalents, loans and receivables, including bonds and other debt securities, equity instruments, which can include shares, derivatives, money market instruments, which include commercial paper, treasury bills, and certificates of deposit, capital market instruments, including stocks, bonds, and other debt securities, and hybrid instruments, which may combine various features. It's crazy, huh? We're learning basically to work in banking. This is all banking. Okay, we're learning to be bankers. So that's why it can seem a little bit daunting at times, because there's a lot of terminology. Even I get a bit, what's the word? I can get a bit overwhelmed, or, you know, it's a lot. So if it's a lot to take in, what I've learned to do is I just allow this information to keep washing over me as I keep studying, and then things start to click. So if it seems like a lot of jargon and terminology in the beginning, just keep letting it flow over you, keep getting familiarized with it, keep hearing it from different angles, and then something's going to start to click. Okay. Brian is giving us some foreshadowing about what's coming up here. And this is part of what makes equity so powerful, because equity recognizes that the courts are banks and that the judges are bankers. and simply asks questions to bring that to light. So that's what makes it so powerful. So let's keep going here. Again, if it seems like a lot of terminology, if it gets overwhelming, just take it at pace. You're going to probably have to listen to this and other content multiple times to really totally inculcate these concepts. So bank, let's look at the definition of a bank. An institution, usually incorporated with power to issue its promissory notes intended to circulate as money, in parentheses known as banknotes. And that's from Black's Law Dictionary, 4th edition. Banking is the business of receiving money, or in parentheses charges, on deposit, loaning money, in parentheses notes. See how these terms are connecting. Discounting notes, in parentheses 100% discount. Issuing notes for circulation, in parentheses promissory notes. Collecting money, which is exemption, on notes deposited, referencing HGR 192. Go and read that. Negotiating bills, which is acceptance, etc. Okay? Some of those words were added by the author. Black's Law Dictionary, 4th edition. Great. How are you guys doing there? Just checking in on y'all. Let's keep going here. Didn't see any questions, so we'll just keep going for now. Written rules. We're talking about these negotiable instruments, right? Rule number 1, it must be unconditional. Number 2, it must be in order. Okay, so we're talking about bills of exchange or unconditional orders. Number 3, it must be in writing. Number 4, it must be addressed to another. Number 5, it must be signed. And number 6, it must order payment of a sum certain in money. Okay, so it must be definitive. Seems pretty straightforward to me. So these are the written rules of bills of exchange. So what are some of the unwritten rules? So we've heard the written rules. Let's look at the unwritten rules. You must have authority to sign it. You must have assets sufficient to back it. It must be dated. It must be dollar to dollar, some certain exchange. It must apply to an existing public debt. It must be a non-cash item. It is not collectible. It is prepaid. It is an accrual item. Always a zero balance, double entry bookkeeping. We're probably going to have to take a deeper dive into that one. It must have a letter of credit to go with it. Pay attention. And this one, I love this one, because this is something I say all the time. Know how to go all the way. Just like crossing the street. What's going to happen if you cross the street and stop in the middle? Comment, what's going to happen if you cross the street and you stop in the middle of the street? Poppy Gold says, if a bill of exchange is ignored, the holder of the bill has the right to enforce it against the parties liable on the bill. Now, why would that be important? Why would that be important? Think about the origin of these bills of exchange back in antiquity, when you literally had merchants traveling around the world, traveling to far off lands, and there was no internet, there was no instant communication to verify their acceptance or to confirm their acceptance. People's lives were literally on the line for the over the acceptance or non-acceptance or dishonor, as we call non-acceptance, of these instruments, of these BOAs. So imagine how important that is. Brian, I agree with you on your comment. I used to be a little bit more, those of you guys who watch some of my previous content or my workshops, you probably remember that I was like, you got to stick to 4th edition, or I used to be a little more of a stickler, and I've realized, no, we need to recognize that obviously they are manipulating the language. So yes, as you move forward in time, there starts to be agendas. That's true. But we don't want to close ourselves off to just using one edition of Black's Law or any reference. So I appreciate that context, Brian. I mean, that's, you know, I'm enough of a man that I could say, well, I needed to soften my perspective a bit. And I want to encourage you guys to think about that, you know, as it makes sense to do that. Special shout out to Christine, who's been following this project and this work pretty much since the beginning. It's great to have you here, Christine. I appreciate you. It's great to have you guys here. And Right Turn Plied says Fruit from a Poisonous Tree by Melvin Stamper is another good book. I have to admit, I have not read that book. So that's a great recommendation. I will definitely take that into advisement, and we'll do some research to learn about that. So I appreciate that. All right, let's keep going here. Question: can I get into trouble filing a UCC1 against the straw man? Okay, what's the straw man? What's the straw man? Comment below, comment in the chat what is the straw man in context, otherwise known as the ens legis, the publicly created corporate entity, legal fiction that essentially represents you in commerce. That is your avatar in commerce. So can I get in trouble filing a UCC1 against a straw man? You can get into trouble for filing a false or fictitious claim. So if your claim is not false, there is no foundation for a false claim charge. If you had no intent to file a false claim, there is no foundation for a criminal penalty. If the claim is considered to be fictitious, you should have documentation to back up the filing. Cause equals choice not to document support the claim. Effect equals false filing charge. The author definitely has a sense of humor, but it's pretty straightforward, right? Be ready. So what's the deeper lesson there? Be ready to back up anything you do. So if you are going to file a UCC1, just make sure that you can back it up with some underlying security agreement that represents your interest in whatever property you are claiming. Okay? That's all it's saying. Just make sure that you can back it up with your documentation. So for those of you who have done or are doing or exploring what is called the secured party / creditor process, not called secured party creditor, it's secured party / creditor, because it's two different terms. You know that one of the things that you do is you create a private security agreement between you as the living man or woman and your debtor, which is the ens legis, and that becomes the underlying basis of your claim of interest in the property of the debtor. Okay? So the cause is you create that underlying agreement, the effect is your claim through your UCC1 is perfectly valid because you have an underlying security agreement. Okay? So we don't want to skip any steps on the journey. We don't want to skip any steps. So let's keep going here. So what is fictitious? Again, from Black's Law, 4th edition, feigned, imaginary, not real, false, not genuine, non-existent. Okay? It's from Black's Law, 4th edition. Black's Law, wow. I mean, that dictionary, or that series of dictionaries has so much knowledge in it. And it's worth, if you can get yourself a hardbound copy of it, that's, I would do that. But, there are downloadable versions of almost all the editions. So grab yourself a copy. Okay, let's talk about the UCC1 form, the parties on the form. So who's the debtor? In this case, it would be John, spelled in all capital letters. Okay. Must have name, address, designated organization or individual, and sometimes have a number. That's the debtor. Again, we're talking about the UCC filing, because UCC filing is serving notice that a security interest exists in some property where there is the debtor, the one who owes, and there's what's called the secured party. So who's the secured party in this case? John, again, but only the J is capital. It's just spelled like in English, John, capital J-O-H-N. Interestingly, there's a little note here. It says in Illinois, both parties must have all capital letters. So there are some variations depending on where you file these forms. You have to be aware of that. And the secured party must have a name and address. Okay. Form must designate collateral and establish a value, but not necessarily a sum certain. And that last point is very important, as I've been learning through equity, because in equity we do sometimes file UCC1s, but there is no sum certain in those cases. Definitely not. But it's still valid. Here's one of the most crucial points. Form must be supported by a security agreement of some sort. The form must be supported by a security agreement. What does the word agreement imply? Consent. Assent, consent, free will, not imposed, not unilateral. Okay? So you can't go and file a UCC1 and say, well, I have a debt against this party if there wasn't consent. Okay? That making sense? And obviously this process is an extensive process. So if you're not familiar with it and you're just dipping your toes in the pool, take it at pace. Okay, take it at pace. Now you have been signing for the debtor since it was created. Again, we're talking about the all caps name, the straw man, the ens legis, et cetera, that was created through the birth certificate, issuing of the birth certificate, and however long you've been signing documents in that name. So when you sign for the debtor, you're wearing an authorized representative hat. Okay? You're also acting as the surety, but you're also acting as the authorized representative, because you are authorized to act on their behalf, because they are a what? What are they? A fiction. Okay? They're a fiction. A created entity. And that which is created by another cannot control its creator. Can't do that. Okay. It's really interesting. I'm learning a lot here myself. Can a man be a secured party on a UCC-1 form without being a fiction? Some say yes and some say no. It's not the form that is the controlling document. It is the security agreement. Here we go. It's the underlying security agreement. That's the one that counts, okay? You can't contract with yourself is a maxim of law, but you can sign the security agreement in a different capacities. One being the trustee of the debtor and the other being you. It's kind of interesting, huh? A little bit of a mind game there. This could be considered to be, quote, self-dealing, but can be overcome as there are no countervailing equities that could serve equally to fulfill the intent and balance the respective obligations. Okay, that's why on the one hand, you might say, well, how can I have a security interest in myself, so to speak? But think about it. The security agreement should identify at least some of the collateral specifically. And if you guys have ever read these security agreements that are created kind of as templates for this secured party process, because there are templates out there, so you don't start from scratch, and you can find them on Scribed. And also shout out to those educators who are specifically helping people through the secured party process. Now, I'm not going to mention them on this stream. I will, however, say that I do have on Sunday, I'm going to be recording an interview with one creator who I've not featured on this platform before. And one of the things she does is she helps people with the secured party process and status correction. So after that, I may be able to mention her work specifically. Okay, because she'll be a guest on the channel. Okay, the security agreement should identify at least some of the collateral specifically. Do not argue with filing officers. There are 6 UCC filing regions. You can file in any state in the region where you want to do the filing. Well, that's good news. Okay. So John, this is John with capital J and the rest lowercase. That's the living man. The creditor, in this case, the secured party. John can be owed money by the debtor even if the debtor is unable to pay. Okay, so the debtor's ability or inability to pay is immaterial in this case. There is a debt. There is an obligation. John, the living man, is substance. The debtor is fiction. The registry at the Secretary of State is both in the Republic and in the nation. I'm not sure what that means. That might mean it's both public and private. I'm not sure exactly what he meant by that. If you know what he meant, comment in the chat. Otherwise, we may have to dive into that a bit. It's okay. We're not going to get everything on the first go here. The debtor, again, the ens legis, the straw man, has no means to pay John, even if the debtor receives public payments for work that John does not be half the debtor for an employer. Okay, I'm not sure what he meant by that. Every service John has supplied to the debtor since John's birth, John the living man, has been done without payment, but not without expectation of payment. Expectation. So the debtor's failure to pay John has resulted in an account payable in favor of John. So that what's the cause? The ens legis, the debtor's taxable activities, that's the cause. And the effect is a tax return is due. What's the cause? John, the living man, supplied labor and hasn't been paid. the effect, there is no deduction. There is no deduction for the accounts payable. So you see how there's kind of a double ledger going on here. By filing the public form in the public registry, the UCC, John, the living man, could be considered a fiction also, but if there is no other way to give public notice of the debt that is owed to John, this is the choice out of necessity. So obviously we're looking to generally operate in the private. And so one might say, well, now I have to go and file these documents in the public. So I'm kind of mixing and going back into the public, but really we're not given a choice if we want to use these systems. Okay. Here's an interesting point. Filing a UCC1 equivalent form in France, so in another jurisdiction, would not make a German creditor a Frenchman. Okay, so you don't assume that you don't take on that jurisdiction just because you're filing in that foreign jurisdiction. It would just out the claim into the jurisdiction of France. Okay, so it's just giving notice. It's not changing the jurisdiction of the party. So UCC1s give public notice that the secured party has a commercial claim, but not that it, meaning the secured party, is in the commerce. Okay. You guys, how you guys doing here? I just want to check in with you. This is a lot. This is why we want to take this at pace. Okay, we've been live for almost an hour now, and we're just getting started. So show me some love in the chats if you guys are getting this. Kind of see where you guys are at. Smash through the like button wherever you're watching this. We have lives going on. This time we're only live on 3 platforms. We are live on my Facebook profile, on the Facebook page for conditionalacceptance.com, and on our YouTube channel. But hopefully what we'll do in future live streams is we will add other platforms like Rumble, LinkedIn, and so forth. So you guys want to keep going? How going to keep going here? Michael says, we are doing good. I appreciate that, Michael. Good to hear. Good. Looks like you guys are doing all right there. Getting some good feedback from y'all. Amazing. David H says, I think I know who David is. Is that my David H down there? Is that my trustee? I'm just guessing because it just says David H, but I don't know a lot of David H's. So I'm going to go out on a limb there. Good to have you in the room. Awesome. Yeah, we're going to keep going here. Let's see if we can get this stream up to 100 viewers. We've got 45. So can we double it? Share this stream. Just share the live stream wherever you're watching it. If you're on Facebook, share it. Share the link if you're watching on YouTube, and so forth. Let's get the word out. That's pretty good. I'm not complaining. It is 42 is amazing. So awesome. Let's go back here. Another question. Are all loans a fraud? Seems like a pretty valid question. Are all loans a fraud? Fraud. An intentional perversion of truth. Intentional. For the purpose of inducing another, in reliance upon it, to part with some valuable thing belonging to him or her, or surrender a legal right. Also, a false representation of the matter of fact. whether by words or by conduct, by false or misleading allegations, or by concealment of that which should have been disclosed, which deceives and is intended to deceive another, so that he shall act upon it to his legal injury. So that's fraud. What is to lend or lend? To put out, to hire, or compensation. From Black's Law, 4th edition. Both of those are from Black's Law, fraud and lend. So the answer, I love this part. When I saw this, this blew me away. The answer depends on where you are going to make your stand. And I see a lot of people struggling with this. And yeah, I mean, this is in network, in conversations with folks. And I went through this in my own mind. I used to think about it one way, and now I think about it a little differently. So really interesting. Yeah. Powerful upgrade here. So the answer depends on where you're going to make your stand. If you're going to use the acceptance method of settlement, then no, there is no fraud. Probably going to need to see what that means. It's just business in a system that has no money. So in equity, I've been studying equity law under a mentor, and this is, we just keep going back to this truth. There is no money, so it's all just acceptances. Okay, just business. That's how we do business in a system that has no money. This is really interesting. Listen to this. Listen to this. If you are going to use conditional acceptance and dispute the procedure, there may be fraud. The procedural discovery will expose the wrongdoing without having to charge fraud. Okay. So it's kind of like now we're moving into a gray area. So when we're doing pure acceptance, just acceptance, no conditions, there is no fraud because it's just business. We already know there's no paper. So we're just accepting everything. Okay. And in equity law, that's pretty much how we do it. Then you have this, if we're going to use conditional acceptance, which is now we're moving into a new realm. And he's saying dispute. So conditional acceptance is, the author is seeing this as a dispute. It's not a hard dispute, but it's kind of like, well, I'll accept that under these conditions. So we're kind of going into that realm of dispute. There may be fraud, but through the process of discovery, we're gonna figure that out. Okay, but the idea with conditional acceptance is you can expose what's going on and you can deal with it without having to go and put a charge of fraud against the other party. Okay, so it's still not definitive. But now we come to what I think most people are doing out there when they realize what's going on. If you're just going to go to a straight out dispute, so what's called a debt dispute, you will have to claim fraud. Fraud involves intent, which is difficult to prove. Okay, fraud involves intent, which is difficult to prove. Remember, when you make claims, you have to what? You have to prove them. Okay. So that means if you're going to make the one who claims presence of a fraud bears the burden of proof. So if you're going to claim fraud, guess who has to prove it? Guess who has to prove it? So you see why when you discover acceptance, how powerful that is? It's just business. We're just accepting it. There is no money. There is no money. We're just accepting it. Okay? Okay, so let's talk about the acceptance method. And I don't know if this book is particularly specifically aligned with equity, It seems like it is, or at least it recognizes that process. So I may add some comments just based on what I've been learning from equity. Just out of curiosity, comment in the chat or wherever you're watching this if you have already specifically begun, like I have, to study equity. I'd love to hear if anybody else other than me has been studying it. So comment in the chat if you have been. I'll also make a quick announcement in that regard. I'm more than halfway through my mentor's course in equity, and my mentor, we've already set up a free live Telegram live for January 11th at 11 a.m. Eastern for about 2 hours. So go ahead and book that in your calendar. January 11th, 2025 at 11 a.m. Eastern on Telegram. We're going to go live. I'm going to go live with my equity mentor, Julian, and he's going to give a presentation where he's going to kind of explain what equity is, how it works as a remedy, and then we'll do some Q&A. So for those of you who are curious to find out more about that, that's going to be completely free. We're going to do it on Telegram. Okay, so just put that in your calendar if you want. Going back here, the acceptance method. So let's talk more about the acceptance method. So the cause in this case, remember, we keep talking about cause and effect. This is a running theme here. The cause is man's intent to use his credit. And the effect is a loan. So the acceptance method, there are no loans without the man's credit. The man puts his credit into the form of a note, in parentheses, a promise. Okay, we know what a note is. The man loans his credit note to the borrower, who is, in this case, John in all capital letters, who is the ens legis, or what some people call the straw man. That's the borrower. So the borrower, who we've also called the debtor or the ens legis, loans the man credit notes to the title company. Check this out. The title company then loans the man's credit note to the mortgage company. And then the mortgage company converts the credit note or the promise into a draft or order. Let me read that again. The mortgage company then converts the credit note or promise to pay into a draft or order. The mortgage company deposits the draft at its bank, thereby loaning the man's credit to the title company. So the bank now has possession of the man's asset, which is the credit note. The bank also has an offsetting liability owed to the depositing mortgage company. The mortgage company writes a check from the account holding the man's credit to the title company. And then the title company writes a check to the seller and keeps the rest to cover its costs, which is its fee. Okay? How about that? What do you guys think about that? All right, you guys are a bit quiet, but that's okay. I know you guys are here because I see we got 53 viewers. That's awesome. We're doing great here. So I know you guys are getting this. Just let it, like I said, just let this keep washing over you. You're probably not even going to get it on the first go, especially if this is the first time you're hearing some of this. Okay. I've been studying this stuff for 2 years, almost 2 years, and I'm still getting in every time I read like this or study, I get insights. So take it at pace. Take it at pace. Okay, so we have this flow in one direction of the passage of the assets, the credit note or just the credit that's being loaned, And then we have, in the other direction, we have the obligation to the principal lender, which is the original jurisdiction. Okay. So it flows from the man to the borrower, which is the ens legis, to the title company, to the mortgage company, to the bank. And then we have to flow back as well. Okay. So who has the asset at the beginning? Who has the asset at the end? Was the asset intended to be given with no expectation of return? Can you really get something for nothing in life, folks? Can you really get something for nothing? What does natural law have to say about this? Even stepping outside of the realm of commercial law. What is there such a thing as something for nothing? I'm not picking on anyone in particular, but I get folks coming to me all the time, sometimes through emails or sorry, I got distracted by a comment. Is there such, let me just reset. Is there such a thing as something for nothing? I remember what I was saying. I get people commenting all the time, whether through social media or direct messaging me, help, I want to be able to just get rid of all my debts. I'm kind of paraphrasing. David, can you just help me magically make all of my debts disappear? And I'm like, no, I can't do that, because there's no such thing as something for nothing. But we can learn together how you can realize the way the system works, and then you can start to perform based on that. And as long as you're putting in your efforts, you know, because remember, it's your energy, it's your life force energy that's on the line here. Okay. So I just want to address this. Valeria says, how do I join your classes? I'm in debt. Help. Please respond back. So other than just joining these lives and the other things I do publicly, what I would recommend for you, Valeria, and for anyone, so we're not doing free live workshops now. These lives are kind of the next iteration of that. The next best thing is to go to the website, conditionalacceptance.com. Let me actually drop a link to that. I think I could do that. Give me a second. I'm just going to drop a link to where you can join the, there's actually two things you can do. Give me a second here. Just post a link to the website, just conditionalacceptance.com. Go to that website, explore it, and you'll find there's a community section. That's where you can join the free community. It's a free private community that's open. You can join through the link. And then there's the membership, which starts at $7.77 a month. And we literally do one private study session a week. So you have 4 opportunities, sometimes even 5 a month, to jump in and meet with me and others and get help on live calls. And then you get access to all the courses on the back end. So a lot of value. So what I would do is jump in there and either join the free community, and if you're able to, join the membership. Like I said, it's tremendous value. Some educators are charging hundreds, if not thousands of dollars every month just to get on a call with them. And you can literally get on 4 calls a month with me for $7.77 a month. I mean, it's insane. I don't know how much longer I'm going to be able to do that, but there is no such thing as something for nothing. So jump in, make the commitment. Otherwise, keep your study up. There is no such thing as something for nothing. Let's keep going here. Where did I leave off? So we said, who has the, I'll just back a little bit. Who has the asset at the beginning? So remember, we have this transaction, right? Who has the asset at the beginning? Who has the asset at the end? Was the asset intended to be given with no expectation of return? Who has the liability? Who is the principal? Okay, so think about it. The cause, what was the cause? The man or the woman loaned their credit. That's the cause point. The effect is the bank now has a liability. Okay, so he's answering the question. Who is the agent? The cause. The man has not redeemed the note, right? So there's a note that has not been redeemed. So what's the effect? The debtor is in bankruptcy. Very interesting. Very, very interesting here. Chad says, make it a lifestyle, learn as you go. I agree with you, Chad. That's how I've done it. I mean, this is all I do now. I could have done something else. I do some consulting, in some other areas related to what I've studied and what I'm good at. But yeah, I mean, this goes deep. And also I would say not just make it a lifestyle, but I would add to that and find the joy in studying this material. Do I give you the impression that this is painful for me? That this is somehow onerous or unenjoyable? You really got to enjoy this stuff. You got to enjoy yourself. And I'm getting a little bit cold here, so I'm going to take a minute to go turn up the heat in this room because I'm in a temporary location. In fact, I'm going to take a quick break here. Let me see if there's a way to pause. You're going to see me walk around here for a second. So I'm going to be right back. Okay, we're not going to end the stream yet. So just hang tight. I'll just put a note here. BRB, be right back. Okay, just give me a second here. All right, I'm back with 55 beautiful souls, beautiful sovereign badasses, or those of you who are on your way to becoming sovereign badasses. Hopefully the background noise is not too much. Let me just catch up on the comments. Michael says, Michael, who's been on the stream, I think pretty much since the beginning, says, I just want to say thank you for all you do, David, for the benefit of your fellow followers. I appreciate you, Michael. I appreciate all of you guys. I do this for you guys, really. I mean, I do it for all of us together. So I appreciate that. Hungry Boy says, you have a great positive vibe like the pops I didn't have. I'm assuming you're probably referring to having like a father figure that someone that kind of set you straight. And I appreciate that. I've also felt a lack of that. I wish my dad had been kind of more of a, I mean, there's no regrets here, and but I wish I'd had more of that growing up as well. So that's really important. Christine says, I deeply appreciate you. Christine, I appreciate you too. Even though we've only spoken, I think one time, I really appreciate that you keep showing up. And that's great. So good stuff, guys. Good stuff. All right, we're back in the hot seat. Back in the hot seat. We're about an hour and 15 minutes, and we're just getting warmed up here. So I guess we'll keep going. We got 50 folks in the house here, 51. Smash through the like button, share the stream so we can get more people involved. We're doing part 1 of reading Creditors and Their Bonds, part 1, and also any Q&A that might be able to come up. So let's keep going here. All right, so let's talk about compensation. Compensation. Let's talk about compensation. Yeah. Okay. You guys tell I'm enjoying my coffee? I hardly have any coffee, actually. Whew, I just got chilly. Glad I turned that heat on. So let's talk about compensation. So, interesting note here, the full scope of the principle of compensation is not addressed in Black's Law Dictionary as well as it is in a law dictionary adapted to the Constitution and laws of the United States of America and of the several states of the American Union. That's actually a title, believe it or not. That's a pretty long title. And that's from 1885 by Bouvier. So it's a Bouvier dictionary, which defines and explains the word compensation as follows. So let's check this out. Compensation. Contracts, civil law. When two persons are equally indebted to each other, there takes place a compensation between them which extinguishes both debts. Compensation is, therefore, a reciprocal liberation between two persons who are creditors and debtors to each other, which liberation takes place instead of payment and prevents circuitry, which he clarifies to mean unnecessary litigation. So how about that? It's a mutual exchange, which cancels out the liability of each party. Fascinating. Number two, compensation takes places, of course, by the mere operation of law, even unknown to the debtors. The two debts are reciprocally extinguished as soon as they exist, simultaneously to the amount of their respective sums. Wow, fascinating. Compensation takes place only between two debts, having equally for their object a sum of money or a certain quantity of consumable things of one and of the same kind, and which are equally liquidated and demandable. So compensation is of three kinds. Number one, legal or by operation of law. Number two, compensation by way of exception. And number three, by reconvention. So we're going to look, he's going to get into more of these definitions. So for now, just let that wash over you. But wow, whew, powerful stuff, huh? Compensation. Okay, let's see how you guys are doing. See what people are saying here. Lisa Marie says, I've got wine, a glass of wine. It's just after midnight in London. It's amazing. Amazing. All right. And Shawanakia, I'm sure I'm butchering that name. I do apologize. Don't beat me up for that. I'm going to have to listen to this again. Yes, you are. And I would encourage everybody to listen to this multiple times. Just like I said, I mean, you're not going to get all this stuff on the first go. Even I don't get everything on the first go. That's not how it works. It's dense. This information is dense. Whatever you study, it's going to take time. Enjoy the process. That's the most important thing. Enjoy the process. Okay. So let's keep going here. So we're talking about compensation. So the keywords from above, the keywords to pay attention to are reciprocal liberation, instead of payment, reciprocally extinguished, and exists simultaneously. Okay, so really interesting stuff going on here. Now, it further goes on to say, as debtors must always acknowledge their obligations to creditors, the principle of set-off applies. And that's from Bouvier's Institute of American Law, 1859, Anderson, A Dictionary of Law, 1893, and Black's Law, 7th edition. Okay, so compensation very clearly resembles the set-off of the common law. Compensation very clearly resembles the set-off of the common law. The principal difference is this, that a set-off, to have any effect, must be pleaded, whereas compensation is effectual without any such plea. Only the balance is a debt. Okay? So what is a pleading? Let's just clarify that. What is a pleading? A formal request, a formal written statement submitted by a party in a lawsuit, typically in a civil suit, to present their claims. Okay, so it's some formalization of the requests. Okay. So compensation is effectual without any pleading, without any plea. Only the balance is a debt. Okay, so we talked about this concept of operation of law. We've mentioned that. So let's get into a definition of what operation of law is, so we can clarify that. Operation of law. This term is applied to those rights which are cast upon a party by the law without any act of his own. Sounds a lot like natural law, doesn't it? Do you have to do anything for natural law to apply to you? Or is it applying anyway? Okay. Operation of law, another definition. The application of legal rules to a given set of facts. That's from Anderson, A Dictionary of Law, 1893. Another definition of operation of law. The means by which a right or a liability is created for a party regardless of the party's actual intent. Regardless of the party's actual intent. That's from Black's Law 7. So a right or a liability can be created on behalf of a party, you or another party, even whether you intended it to be that way. Whether or not you had a specific intention. Okay, so let's look at the word compensation. From Roman law, a defendant's claim to have the plaintiff's demand reduced by the amount that the plaintiff owes the defendant. That's from Black's Law Dictionary, 7th edition. Let's read that one more time. Compensation. From Roman law, a defendant's claim to have the plaintiff's demand reduced by the amount that the plaintiff owes the defendant. Okay, let's look at the word set off. Set off with a hyphen. Both at law and in equity, that right which exists between two parties, each of whom is under an independent contract, owes an ascertained amount to the other to set off his respective debt by way of mutual deduction, so that in any action brought for the larger debt, the residue only after such deduction shall be recovered. So now you know, well, you're starting to get the picture. Why in equity, when you asked for set off, that the account be set off, you have every right to do that because there is no money. And you've loaned your credit to the public side. Okay, so there's a crisscrossing that's going on here. You're like, well, great. Set that off. Compensation. Okay, you starting to see how the dots are starting to connect here. So let's keep going here. Earlier, we used this term holder in due course. So what does that mean? What is a holder in due course? So we're going to go back to the UCC, and specifically, we're going to look at UCC 3-301, holder in due course. Item A, subject to subsection C and section 3-106D, holder in due course means the holder of an instrument if, what's an instrument? A negotiable instrument. Holder of an instrument if, number one, the instrument when issued or negotiated to the holder does not bear such apparent evidence of forgery or alteration, or is not otherwise so irregular or incomplete as to call into question its authenticity. Okay, so we have a valid instrument. That's basically what it's saying. It's a valid instrument. And, excuse me, the holder, number two, the holder took the instrument, number one, Roman numeral 1, for value. Number two, in good faith. Number three, without notice that the instrument is overdue or has been dishonored, or that there is an uncured default with respect to payment of another instrument issued as part of the same series. Number four, without notice that the instrument contains an unauthorized signature has been altered. Number five, without notice of any claims to the instrument described in section 3-306. And number six, without notice that any party has a defense or claim in recruitment described in section 3-305A. All right, that part made me sweat a little bit. Okay, it's a lot. It's a lot. Holder in due course. Okay, so we're talking about a valid instrument. There's no irregularities. The holder took it for value and in good faith. And there isn't any indication that it's overdue, it's been dishonored, it has any defects, it's a forgery, anything like that. Okay, so we're talking about holder in due course. So let's look at number B, or letter B. It's getting a bit wordy, so just hang tight, hang tight. We got to get through this. Notice of discharge of a party other than discharge in an insolvency proceeding is not notice of a defense under subsection A, the one we just read, but discharge is effective against the person who became a holder in due course with a notice of the discharge. Public filing or recording of a document does not of itself constitute notice of a defense, claim in recoupment, or claim to the instrument. Okay. Letter C, except to the extent of a transfer or predecessor in interest has rights. I'm sorry, let me reread that. Except to the extent a transfer or predecessor in interest has rights as a holder in due course, a person does not acquire rights of a holder in due course of an instrument taken, one, by legal process or by purchase and an execution, bankruptcy or creditor sale or similar proceeding. Number two, by purchase as part of a bulk transaction, not in ordinary course of business of the transfer. Or three, as the successor in interest to an estate or other organization. Okay, this is getting pretty technical. My head is starting to break open here too. So if yours is, hang in there. Okay, this is complex stuff. All right, hopefully we're not losing too many people here. Just make sure I don't lose my place here. We're going to be getting to the goodies about acceptance soon, so we're just building up to that, just in case you guys are wondering. I mean, we're literally on page 12 out of 125 pages. So we're just getting started here. So just getting started. All right. Okay. Let's keep reading. Item D. If under section 3-303A of the Uniform Commercial Code, item 1, the promise of performance, that is the consideration for an instrument, has been partially performed, the holder may assert rights as the holder in due course of the instrument only to the fraction of the amount payable under the instrument equal to the value of the partial performance divided by the value of the promised performance. Okay. So that's how partial performance is handled. And finally, E, I shouldn't say finally, E, if number 1, the person entitled to enforce an instrument has only a security interest in the instrument, and 2, the person obligated to pay the instrument has a defense, claim in recoupment, or claim to the instrument that may be asserted against the person who granted the security interest, the person entitled to enforce the instrument may assert rights as a holder in due course only to the amount payable under the instrument, which at the time of enforcement of the instrument does not exceed the amount of the unpaid obligation secured. So we're talking about crossing, set off. Again, we're talking about crossing these obligations. Okay, going back to this idea of compensation. Okay. Letter F, to be effective, notices must be received at a time and in a manner that gives a reasonable opportunity to act on it. Okay, that's just being honorable, right? Letter G, this section is subject to any law limiting status as a holder in due course in particular classes of transactions. Okay, so if you're sweating about that, that's okay. Like I said, you always got to let it wash over you. Okay, so I'm just checking in with you guys to see how everybody's doing. We're rocking and rolling. We're about an hour and a half in. We still got about 50 so folks on the streams across these different platforms. So what I want you to punch right through that like button wherever you are. Just smash it, obliterate the like button as a way to get this out. That's essentially how you're paying for this free content. Okay, remember, there's no such thing as something for nothing. We got to be consistent here. Okay, you need to get up and stretch. I've been sitting here. I've been wanting to do these live streams for a while now as a way to change it up, because I've been doing the free workshops. I did them from about May until October. So that's May, June, July, August, September, for about 6 months. And they changed a little bit over time, but we didn't really branch out into anything new. So I've been wanting to, that's one of the reasons why I've been switching to this new format, because I've been wanting to do more. I've wanted to branch out and kind of study special topics, do these readings and look at things, go deeper into this content than the course itself. And this is what's really allowed me to do that. So I appreciate you guys being patient as I've kind of taken this in a whole new direction. So at this point, I don't know. There probably won't be workshops on Saturdays because Saturday is the one day a week where I haven't done workshops. I kind of take that day off. But if the question is when there would be free workshops, I mean, this is it, folks. This is the new free workshop format. Okay, it's just we're going to be covering special topics. So right now we're doing a reading of Creditors and Their Bonds, which I highly recommend that you guys read. And then we'll probably cover other topics as well. I mean, just the sky's the limit. Okay, and when we launch the new brand, which is going to take over instead of conditionalacceptance.com, the new brand is going to be much broader in scope. It's not too broad. It'll still be focused on freedom and sovereignty and becoming the creditor, assuming the role of the creditor, but it will also have an expanded scope. So it's actually going to allow us to cover a much broader realm of topics. So stay posted. If you want to go back and watch the replays of some of the previous workshops, you can do that through the membership. Okay, so let's keep reading here. Let's talk about recoupment. We've used this word a couple of times, recoupment. Very important to define these words. Recoupment. The right of the defendant to have a deduction from the amount of the plaintiff's damages for the reason that the plaintiff has not complied with the cross obligation or independent covenants arriving under the same contract. That's from Black's Law, 4th edition. Recoupment. Okay? So the plaintiff's making some claim, and the defendant's saying, hang on. Under the same contract, there's something that hasn't been addressed in the other direction. So we need to have a recoupment there. Okay, what does accepted for value mean? And this is a controversial topic. I know my mentor in equity has said multiple times that, and others have said, there is no such thing as accepted for value. It's a fabricated term, but let's just, suspend our judgment for a second and let's see what he has to say here. What does accepted for value mean? Well, let's look at acceptance. That's the first part of it, right? Acceptance. The taking and receiving of anything in good part, and as it were a tacit agreement to a preceding act, which might have been defeated or avoided if such acceptance had not been made. The act of a person to whom a thing is offered or tended by another, whereby he receives the thing with the intention of retaining it, such intention being evidenced by a sufficient act. Let's read that one more time. Okay. The taking and receiving of any, so acceptance, the taking and receiving of anything in good part, and as it were a tacit agreement to a preceding act. Okay, so I'm accepting a previous act, which might have been defeated or avoided if such acceptance had not been made. The act of a person to whom a thing is offered or tendered by another, whereby he receives it, the thing, with the intention of retaining it. Such intention being evidenced by a sufficient act. So it has to be clear that there was acceptance. Okay, that's what that last part means. Acceptance has to be clear. It has to be clear that that was the intention. Okay? Can't be guesswork there. So really, really important. How are you guys doing there? Okay, so there's a lot of chat in the comments. I'm not seeing any questions though. Give me a second, just want to check something here. So we're just going to read a little bit more, and we're coming to what looks like a good breaking point between now and the next time we do a live. So we'll stop reading just a little more, and then we're going to stop reading, and then I'll just leave it stream open for a little bit, maybe for some Q&A and interaction with you guys. How does that sound? Because we're coming close to 2 hours. So let's go here. Okay. So let's look at UCC 3-303, which is called value and consideration. An instrument is issued or transferred for value if, okay, number one, I'm sorry, A, an instrument is issued or transferred value if, number one, the instrument is issued or transferred for a promise of performance to the extent the promise has been performed. Number two, the transferee acquires a security agreement or other lien in the instrument other than a lien obtained by judicial proceeding. And number three, the instrument is issued or transferred as payment of or as security for an antecedent claim against any person, whether or not the claim is due. Number four, the instrument is issued or transferred in exchange for a negotiable instrument. Or number five, the instrument is issued or transferred in exchange for the incurring of an irrevocable obligation to a third party by the person taking the instrument. Okay, so that was A. So go read UCC 3-303. So let's look at B. Consideration means any consideration sufficient to support a simple contract. The drawer or maker of an instrument has a defense if the instrument is issued without consideration. If an instrument is issued for a promise of performance, the issuer has a defense. The issuer has a defense to the extent performance of the promise is due and the promise has not been performed. If an instrument is issued for value, as stated in subsection A, the one we just read, the instrument is also issued for consideration. Okay? So let's keep going here. Official comments. The distinction between value and consideration in Article 3 is a very fine one. Whether an instrument is taken for value is relevant to the issue of whether a holder is holder in due course. Okay? If an instrument is not issued for consideration, the issuer has a defense to the obligation to pay the instrument. Consideration is defined in subsection B as any consideration sufficient to support a simple contract. Remember what we said about consideration. What is consideration? Go back to listen to what we talked about. It's the exchange, the immediate set-off, okay, the immediate interchange of value. The definition of value in section 1-204, which doesn't apply to Article 3, includes any consideration sufficient to support a simple contract. Thus, outside Article 3, anything that is consideration is also value. A different rule applies to Article 3. Subsection B of section 3-303 states that if an instrument is issued for value, it is also issued for consideration. Okay, so let's just talk about one last thing here. Let's talk about a simple contract, and then we're going to finish our reading for today on page 13. And we'll continue for the next time. So let's talk about a simple contract. A simple contract is one that is not a contract of record. It is not under seal. It may be either written or oral. In either case, it is called a parole, P-A-R-O-L, or parole, I guess, parole contract. The distinguishing feature being the lack of a seal. And that's from Black's Law Dictionary, 4th edition. So let's look, except for value, taking in exchange for a promise or a performance, receiving in exchange for a security interest, intent to retain, not obtained through judicial proceeding, of anything in exchange for antecedent claim, offer in exchange for a negotiable instrument, presentment in exchange for irrevocable obligations. I may have read that incorrectly because it's kind of in columns. Might have to do a screen capture for that one. Okay. So, oof. Who else's head is exploding at this point? Who else's head is exploding? It's a lot. It's a lot, folks. Okay. Hopefully you got something out of this. Let me see where you guys are at. I'm seeing some questions. Is it imperative that one become a state national? Okay, so what's a state national? Okay, where were you born? Okay, where were you born? I was born in Pennsylvania. Okay, so that means I'm a Pennsylvanian. Now, do I have to declare that to be a Pennsylvanian? No. Can making that declaration help in certain cases? Yes, it can. Okay, so there are certain benefits to declaring your status, but you are a national or sometimes people call it a state citizen of whatever state you're born in, or whatever, region, state, or jurisdiction you were born in. Okay? Whatever territory that is. So we finished the reading for today. So I'm just going to stay on here and just interact with you guys. I appreciate you very much. I didn't even announce this live, so this was impromptu. And someone asks, is the PDF available? Yes, I believe it is, but if it's not, just let me know, and I will add it. I'm pretty sure that it's up there. But if it's not, you could also grab a copy from Scribd, SCRIBD. In fact, I think if you just do a straight internet search, you can come up with it pretty easily. But if it's not there, I know somebody also shared it in our Telegram. So if you look at the documents section under Telegram, it's there as well. But yeah, just send me a private message if you can't find it, and I'll make sure it's up there. Okay. This is a lot of stuff going on. Take it at pace. You're learning. You're learning how to operate properly in commerce. You're learning how to operate as a private banker. You are learning how to manage your own affairs. Okay. And this need only be a part of what you study. I mean, you probably have your own affairs. You may have a business or several. You may be operating commerce privately. You may be operating publicly, and so forth. So just take it at pace. Jerry says, I'm so glad I got you live. Yeah, me too, Jerry. I probably, I'm going to think about maybe scheduling this. It's with my schedule, it's just been very hard to create a consistent schedule. But what I may do is just come up with a consistent schedule, because I know that makes it easier for you guys to join. So let me give some thought about when would be the best times to do that. And then I'll see if I can make that happen. But I want to at least narrow it down maybe to a day of the week, if not a time of the day. Pecan Farmer says, oh, I love pecans, by the way. I don't know. Are you really a pecan farmer? Because I love pecans. They're delicious. Thank you for everything, David. I do need to get with you a couple of things private. Okay, so for anybody who wants a private, let me share the link to that. Give me a second. We actually now have 2 team members that are taking private consultations. There's myself and Blue. So this will allow me to make an announcement here. So I'll share the link here real quick. It's all through the website. Okay. So you can either do a consultation with me or with Blue. And when you go to that page, you'll see what each of us is focused on. So make sure when you choose, looks like it didn't let me post it. Oh, it let me on some destinations. I guess it wouldn't allow me to post it everywhere. But you just go to conditionalacceptance.com and then go to services, consultations, and you can schedule a one-on-one with me. There's an option to schedule with either me or Blue, depending on your topic. So look at what we each talk about and then select accordingly. And there's also an option for what's called a priority consultation. Now you're going to have to pay more for this, but it allows you to get to me within the next 7 days, depending on my availability. So it's a little faster. Okay. So go ahead and let's see what else. Magic Nova says, great to finally make a live. Yeah, I mean, this is the first time I'm really going live in this format, not in a workshop format, because the workshops were never live on social media. So, I mean, this is really something new. So it's kind of groundbreaking. I've been wanting to do this. There's other content creators that have been going live in this space. And this is not, I'm not trying to compete with them, but I've enjoyed, I enjoy that model, and I've appreciated the value of doing that. And so, yeah, I finally made it happen. So it's great to have you here as well. It's pronounced pecan. Yeah, pecan. I've heard it pronounced pecan, 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 whatever. There's a lot of different ways to pronounce it, but they are delicious. Yeah. So let's see what other people are saying. Great. Using a closed checking account. Are you referring to an account that's a non-interest bearing account? What did you mean by closed in that case? So pecan or pecan farmer says, get me a good address in private. A couple run over. Yes, I'm really a pecan farmer. Well, I'm not sure what you mean by good address in private. Jerry says, just curious, what was the story of how you learned? How did I learn? How did this all come about? I mean, I've probably talked about this any number of times, but I started studying natural law before I got into commercial law. And so it was kind of like a natural segue where after learning about natural law, which I discovered, so taking a step back from that, when the fabricated orchestrated event that occurred in 2020 occurred, that I'm not going to mention just so I don't get a strike on certain channels. It was pretty obvious to me that it was all socially engineered, that it was a well-designed event. It was not just a naturally occurring event. So I just saw that immediately, but I was feeling frustrated because I felt like there were some underlying principles that I was not getting. I wanted to understand how they were getting away with these things at such a massive scale, and what I could do as one man to kind of stand up to that. So that's how I started learning natural law. I learned it principally through Mark Passio, through his seminar. It's called Natural Law, the Real Law of Attraction, How to Apply It in Your Life. So that basically shook the foundations of my life. And then, of course, I got into the whole realm of the content creators and the other educators that he had taught, or people that were kind of studying in parallel, and just went deep into that. But I still felt, even after studying that for a couple of years, I felt like, well, that's all well and good, but where's the remedy? Or, I didn't really know the word remedy at that time, but how does one get out from being a debt slave? Basically, how does one get out from, knowing natural law? How does one then take that and start to apply it in a more practical sense? And that's when then the laws of commerce and, law of merchants, conditional acceptance, and then later equity, that's when those things started to appear for me. There's this saying, when the student is ready, the teaching will appear, or the teacher will appear. And so that's essentially what happened. And that happened for me in early 2023 is when I started discovering these principles. And then I just, what I do is when something resonates with me, I just go deep into it. I just keep studying and keep peeling back layers, and there's always more. And there's even things that I don't really talk about or haven't talked about, about the deeper nature of reality that I would like to. And I think the expanded scope of what I'm doing and the new branding of this platform will allow me to do that, because it's not going to be so specific. Okay. It's going to be more about, it's going to all be based on freedom, and particularly freedom of the mind, because that's where it really all starts. And, but it's going to unfold it, in layers. So let me just see what you guys are sharing here. Okay. Let me see. Hope you incorporate certain spiritual. Yeah, everything is spiritual. In fact, I would even take that a step further. If you try to do anything, just from a materialistic perspective, you're going to fail, because the entire realm, this is a spiritual realm. Everything is emanating from spirit. So for those of you who don't know, I don't like to put labels, but I guess if you were to ask me kind of what my beliefs or kind of my understanding of reality is, I'm an animist. So animism is basically this belief that everything is alive, everything that exists, all of us and everything in creation exists essentially in the mind of the all, which is the creator. So everything is self-contained. There is no separation. Okay, and everything's alive. This computer that I'm using to broadcast, this computer equipment it all exists in the mind of the creator. Everything is alive. So that's my belief. So everything is emanating from the spiritual realm. So if you try to approach these things from a purely materialistic perspective, it's going to be a struggle. And I'm not saying you couldn't, get some progress, but I would think, just from my own experience, that you would run into a lot of obstacles, in terms of that. So, but I don't take a religious stance. In other words, I don't try to impose a belief system on anyone. It's more about discovery. It's more about, let's discover together how things work. Let's have open eyes. Let's be open to, being wrong and realizing that we were wrong, and, making a correction. See what you guys are saying here. So has this been helpful? Has today's live been helpful? Has this been helpful for you guys? Okay, some folks are having a chat here in the about specific topics, which is fine. So if you guys want to connect in network, we do have the community. You can do that. If you're a member, we do have the private community, which is a little more, I wouldn't say it's small, but it's a little more self-contained. We do have folks that have networked regionally. In other words, we have, and these are not officially sanctioned. Like, these are not controlled by me or any organization. But we've had groups crop up, for example, in California and Florida and other parts of the world. So I encourage you guys to connect with each other. I sometimes talk to people on the phone or in consultations, and they're very frustrated. And a lot of times they're trying to do everything alone, and that's not a good idea. So what I recommend is that you network with people. Now, if you can find people locally in your area, that's going to be really, really valuable. But connecting online is okay. I mean, we live in a world where we have a lot of connectivity. So if you want to also connect online, then you can do that. So Graciela says, how to do it in Spanish? Well, that's a great question. I speak Spanish fluently, so I can definitely appreciate that question. It's probably a good idea to connect with people. I haven't done content of this type. I have done some content on natural law in Spanish. So if you go to my Freedom Vibe channel, on YouTube @ Freedom Vibe Art, there are a couple of videos in Spanish, but that's specifically on natural law, not on commercial law. So maybe at some point I will do something in Spanish on these principles. So let's see what other people are saying. Christine says, I need to network for sure. I've been alone way too long. Yeah, I mean, it could be as simple as posting. You may have to post a couple of times. People are busy, and you can't really control if someone's, who's going to read your post any given time. And there's a lot of, it's a very active online community. So you may need to post a couple of times. You may need to come back and remind people that you're there, and network with people. And that's cool. Just do that. And over time, you build up your circle of friends, colleagues. Sometimes people are even acting as trustees for each other, in terms of setting up trust. That's another thing we're going to talk about a lot, is trusts and setting up trust, operating in the private member associations. So a lot of stuff. We're coming up almost on 2 hours. So I'm going to wrap up here in the next couple of minutes. But I just want to say that I really appreciate you guys. And yeah, I really appreciate you guys. And again, I didn't if you were just able to jump on, you're like, wow, I didn't know this was going to happen. It's because I didn't schedule it. Okay, so it wasn't you, it was me. But I'm glad you made it, and keep up the great work and keep getting involved. You know, we're going places. Okay, so we're going places, and a lot of good stuff is coming. So you guys are in the right place. I appreciate you guys a lot. So we're going to wrap up here, and very soon, hopefully within the next week or two, we'll continue with Creditors and Their Bonds Part 2. It's obviously going to take a while because we only got through about 10% of the book today. So probably is going to be a series of up to 10 lives. So you can at least count on that. And the next time you guys hear from me, I'll probably be in Colombia, in Cali, Colombia, in South America. So I will talk to you guys very soon. All right. Take care, everyone. Be well.